We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Welcome back to Liberty Nation Radio. I remain your host, Mark Angelides. We're very fortunate to have with us Liberty Nation's legal affairs editor, Scott Cosenza, to talk about the pushback to the Bruen decision that is taking place in New York right now. Scott, thanks for being here.
Thank you, Mark.
So, Scott, the Bruen decision from the Supreme Court essentially ruled that everything must be examined through the lens of Bruen in terms of what gun restrictions may be applied across the country. But now it seems that New York has decided to try and, well, previously it seems that New York had tried to buck that, but that a recent decision has had some clawback. What's the situation?
Well, I don't know that I would put it exactly how you did. And so let me just walk back just for a skosh that they said that everything would have to be judged through the lens of Bruen. What they said in Bruen was that everything had to be judged through the lens of historical context. And so what might have been legal or was legal at the time the Second Amendment was adopted is something that could be, prohibited, actually. I should have stated it in the negative, which is what the Supreme Court would have said. So what might have been prohibited at the time of the adoption of the Second Amendment might also be prohibited today if there's historical, relevance or resonance to it. And that's what the court said here. Judge Sinatra, a federal judge in the Western District of New York, heard this case. And in 2022, the man's name is Mr. Christian, I believe, sued to have the new New York law stopped, and he was successful in getting an injunction against it for the meantime. So they passed a law, Kathy Hochul and the notoriously anti-gun New York State Assembly passed this bill that said, if you have a license to carry a firearm in New York, or you're legally allowed to carry a firearm in New York, you are not allowed to do so on private property unless you know for sure that private property owner welcomes your carry on that property. And, I just thought about it in the free speech context, Mark. You can imagine them saying in New York, you're allowed to have a MAGA hat and you're allowed to wear your MAGA hat in public, but you're not allowed to wear that MAGA hat into a business unless you know for sure through prominent signage posting that MAGA hats are welcome there. It's kind of preposterous, right, if you put it into another context. Well, that's what they did for guns. This was just a reeling measure when the Supreme Court, it seemed, was forcing them to honor the Second Amendment rights of the citizens of New York, which is something that they've been notoriously hostile to. And they tried not to do it by saying, we'll just make it impossible. Mr. Christian, he wanted to go carry his firearm, for instance, when he got gas, on the way from point A to point B. This law would prohibit him from doing that, for instance, from weekly trips to the gas station, and said that it made the exercise of his right basically impossible. Well, Judge Sinatra of the Western District agreed when he granted the preliminary injunction, and now we have the ruling in chief, and the ruling says that doesn't pass constitutional muster. So that's the current ruling. New York State may not enforce this law. I'll hasten to add, before you get into any questions, that we should expect to see the hostile to gun rights authorities challenge this, which the next step would be the Second Circuit Court of Appeals, and then we presume that whoever loses at the Second Circuit would appeal again then, and that would be to the United States Supreme Court.
So as of now, the right to carry a firearm in New York is, they don't need to look for a specific piece of signage to say gun carriers welcome here. They can do so and not face legal jeopardy just by wandering around doing their shopping.
Yes, Mark. When the right to keep and bear arms movement produced a lot of victories for the right to carry in many states, going from what were called may issue to shall issues. So when state authorities were required to issue permits to applicants who met a certain list of criteria rather than left it to the government officers' discretion, one of the things that some jurisdictions did was required large signage if they were going to prohibit gun carry. So, for instance, a shopping mall, if they wanted to prohibit the carry of guns, they would have to post on all entrance doors a signage of a certain square inches. For instance, only with the diabolical lawmakers in New York did they think to kind of flip it on its head. So people still may want to look out for signage indicating they're not welcome in New York, but they don't have to look for signs indicating that they're welcome to exercise their rights.
I believe you and I have discussed this before, Scott, but if you're talking about the big fancy shopping districts in New York, the windows there, that's prime real estate in terms of what signage goes up. And I would think that even just the displayment of signs would be onerous to some degree, wouldn't it?
Well, any imposition like that, I think, is onerous. But this is about how can they kind of establish a basis for trespass, and it's their private property, so they don't have to put the sign up. They only have to. And by the way, so right now we're not talking about New York because this is not a law in New York. This is a law in some other states, whereby if, for instance, let's just use the shopping mall example. It's easy to use. If a shopping mall wishes to be able to trespass people who have firearms or are in possession of firearms, they have to provide notice. Otherwise, it's not an offense against them, just like wearing the MAGA hat, for instance. And so the law has settled on that signage as a requirement for the notice. So I think it's, it's not that great an imposition on the place, on the mall, for instance, in the hypothetical, if that's what they want to do, to bar people who are exercising their right to keep and bear arms.
Well, we'll be following this very, very closely as it bounces back and forth between the various courts over the next year or so.
Well, we can pause in the very close for at least a number of months, because the Second Circuit, I imagine, is not going to get to this until well into 2025.
And that's some freedom for New Yorkers there, which is always a good thing. Extra freedom. Scott Cosenza, thanks ever so much for joining us.
Cheers.
And that's all we have time for on this week's edition of Liberty Nation Radio, heard coast to coast on the Radio America Network. I've been your host, Mark Angelides. I'd like to take a moment to thank our guests on today's show, Tim Donner, Scott Cosenza, and John Parker of Sheepdog Impact Assistance. And of course, thank you, the listeners, for taking the time to tune in each and every week. And I'd like to remind our listeners that Liberty Nation does not endorse candidates, campaigns, or legislation, and this presentation is no endorsement. Thanks for being here. We'll see you next week.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.